again, with titling, this is one that I get asked all the time. And I, always preface, well, I'm not an attorney, but, let's talk about the idea of joint titling. Now, if you're a married couple, then there's some advantages to joint titling.
That's true.
Right? Like, for instance?
Well, in Michigan's what's referred to as, an entirety state, meaning that real estate that's held jointly by a married couple is basically completely off the table for creditors. So, for example, if I get sued and I own my personal residence with my wife, that property can't be touched. It's not collectible, not subject to litigation. So that's one advantage. And there's several other advantages. One of the other issues as well in joint titling between a husband and wife is, as you're aware, when you go to sell that property, there's a $500,000 capital gains exemption. That's why most people, when they sell their own residence, unlike investment property, they typically pay no tax on it. And that's all a consequence of properly setting up as a joint title between husband and wife.
Yeah, so again, there's a lot of overlap, Tina, when it comes to real estate, estate planning, titling, strategies for taxes. That's why we're glad to have Ron Thompson of Thompson Stewart PC in, because he is an attorney. You know, when you're a real estate broker, that's an important distinction. You make sure you explain, I'm not an attorney.
You're right, and you should ask an attorney.
And you should consult one.
Yes.
Which, Ron, that's just always good advice, right? When people are getting into where their money's getting sunk into properties or businesses.
Biggest part of where their money's getting sunk into.
Yeah, I mean, typically, right? I mean, that's typically your biggest purchase, American Dreamer, is your home. And so you want to make sure you're consulting with the right sort of attorney. And I don't want to say anything against any attorney in particular, but not all of them are experts in real estate.
That's true, and unfortunately, I find, Paul, a lot of estate planners are not real estate people, and so what ends up happening invariably is they'll set up the trust correctly for a client and the other estate planning pieces, but they won't have the real estate title correctly. And from my perspective, one of the reasons you do estate planning is to make sure that your assets transition to your heirs tax-free, probate-free, and it doesn't create any unnecessary exposure. And if you don't have that titling set up correctly, and frankly, I see a lot of times estate planners will not do that. They'll use things like ladybird deeds and quitclaim deeds that frankly create more problems than they fix.
Okay, well, let's jump to that. It was number 6 on my list. But you mentioned ladybird and quitclaim. Why could these be problems?